judicial criminal trial. Number 2, the public interest, order, and security. It is not in doubt that this is one of the great matters of the greatest public interest in the country at the moment. Number 3, the needs to preserve the integrity of the administration of justice. We will discuss that in a minute. And finally, and the interests of victims of crime where appropriate. And Your Honor, the court, in cracking its head about it, continues to say, by virtue of Articles 21(1) and 259 of the Constitution, the court must act to aggrandize, not diminish, the personal liberties of arrested individuals in line with the other 3 interests. But importantly, differently put, the state must demonstrate that there are compelling reasons to deny pre-charge bail, while balancing all factors within the complex permutation presented by these quadruple interests, and without reifying or essentializing any. I dare say kizungu kubwa. Having highlighted those 2 tests, Your Honor, the state is acting in utmost absolute good faith to have presented the respondent within a reasonable time before court. Other than in the police cells, through the affidavit before you, the respondent has been informed, 1, of the reason of his arrest, and 2, of the reason why the state seeks to continue to detain him. That is a show of utmost good faith. Your Honor, in insurance law, it's called uberimai fidei. That good faith is furthered by the fact, as my learned senior will tell you in the facts, or rather in the affidavit, that there has been some investigations ongoing, and that we just need a limited period within which to complete those investigations. And finally, from my part, in compliance with the need provided for under Article 24 of the Constitution, that the limited detention of the respondent is the least restrictive measure we could adopt to protect both the interests of the respondent, the victim's interests, and, as equally important, the interests of the public to ensure safety and security. With that legal background, I invite my learned senior, Mr. Jalson Makori, to take you through the factual matrix in the affidavit. I am most obliged unless there's a question for me.
All right, thank you.
Thank you.
Counsel.
Your Honor, Makori.
Yes.
Your Honor, we are referring to the affidavit by one Abdurrahman Jibri. Abdurrahman Jibri, dated the 16th of June, 2025. It is an affidavit in support of the notice of motion, dated the 16th of June, 2025. Your Honor, I will only I will only highlight the paragraphs that are in the affidavit. Paragraph 6 sets out the background of the investigation. And these are the preliminary investigations by IPOA, which reveals in paragraph 6A to E, 6A to E, that is on the 4th of June 2025, the DCI received a complaint from the DIG of police, Mr. Eliud Langat, alleging he suffered continued false and malicious publications on an X account, formerly Twitter, with the username Pixel Pioneer, and requested investigations with a view to establish the person and motive behind it. Your Honor, A to E establishes the grounds in which the investigations were mounted. It is at paragraph 6B. On the 7th of June, the DCI team went to Linda Center in Homa Bay County and arrested the deceased at around 2:30 p.m. And they took him to Mawengo Police Station, placed him in custody with the OB number 10/7/7/6/2025. That is 10/7/6/2025. Then at around 3:54 p.m., the deceased was booked out under OB number 11/7/6/2025 and escorted to Nairobi, where he was booked at Central Police Station under OB 136/7/6/2025 at 9:32 p.m. Your Honor, we have annexed to paragraph 6E the OB extract, that is AJ1, indicating the time that the deceased was booked at Central Police Station. Paragraph 7, Your Honor, the respondent was arrested, and this is something that would wish the court to take notice. The respondent was arrested on the 13th June 2025 at 18:05 hours, that is 6:05, which was on a Friday. The respondent in paragraph 8 was informed of the reasons of the arrest and for which and the reasons and of the offense that is being investigated. That is under paragraph 8. Your Honor, in paragraph 10, now we are coming to the reasons why we want to continue holding the respondent. The respondent is the custodian of the station records, being an OCS, officer commanding station, and the surveillance system, the CCTV. And this is at the material time under the investigations. Your Honor,
the information the DPP is giving, it's not the who informed. It is the one who informed who should be giving us those paragraphs. We can talk about it because then the DPP can address their submissions based on that. Right now, the DPP is turning himself into a witness. We cannot cross-examine the witness. It is fair and just. The witness who the pawn takes us through is affidavit.
Your Honor, as I said that I'll only highlight a few paragraphs which I wanted the court to take note of.
You know, that's a dicey,
Because-
it's a dicey situation because
Yes.
you're literally taking us through the
I-
affidavit. But I leave because I'm sure you have your own strategy
Yes.
on how to prosecute the application.
The
but
defense-
don't go into details
Yes.
of the affidavit. I'm sure the department will have a chance.
Yes.
So I'll leave it to proceed, but don't go too much into it.
No,
of the position.
No, Your Honor, I'm only highlighting some paragraphs. I'm not going through the whole affidavit because they have already indicated that they want the deponent on the dock for cross-examination. Yes. Your Honor, what we are...
CCTV, maybe to
Yes,
refresh
yes,
the
at the
record.
CCTV, yes. We say paragraph 10, the respondent is the custodian of the station records and the surveillance system, that is the CCTV, that is under investigation. Yes, investigations reveal that under paragraph 11, that the respondent, together with others who are not before court, hired a technician to interfere with the CCTV system at the Central Police Station in a bid to tamper and interfere with the subsequent investigations. Your Honor, we are highlighting what so far we have done insofar as investigations are undergoing. So there is still some investigations which we need, and that is the reason why we are asking for continuing detainment of the respondent, because the respondent's mobile phone has been detained. And it is subject to investigations. Your Honor, there are also witnesses who are yet to be investigated and statements taken from them. Also witnesses, police officers who are on duty at Central Police Station on that night. Your Honor, given that the respondent is the OCS, we are saying that there is a likelihood that he may interfere with the investigations. Your Honor, we'll be seeking the 21 days. To continue holding the respondent. And in addition to the 21 days, Your Honor, we'll be seeking an order that we access the phones of potential witnesses, the police officers who are on duty, and any other person who was at the vicinity at Central Police Station. And this, Your Honor, we are relying upon paragraph 17 and 18, where we have shown in the paragraphs, we have demonstrated that there is already interference, which has already been done. With that, Your Honor, we will be inviting the deponent to the dock for the cross-examination.
Whenever you're comfortable.
Yes.
Yes. Cannot we be seeking that these are findings to an opening step will be allowed at 3 minutes for opening step?
No, let him finish.
What?
Let him finish, and then you have your chance. Let him finish, so that there's that continuous talk. So let's see.
Yes.
Yes, please.
Bismillahirrahmanirrahim. I swear by the name of the Almighty God, that the evidence I shall give before this court, touching the matter in question, shall be the truth, the whole truth, and nothing but the truth. So help me God.
You state to the court your full name.
Your Honor, I am Abdurrahman Jibril. Jibril for you, Jibril. I'm a Senior Assistant Director, Investigations with the Independent Police and Oversight Authority.
Yes. Did you form this affidavit at the before court?
Yes, Your Honor.
Yes, kindly proceed with the affidavit. There will be questions given from the defense.
Thank you, Your Honor. Your Honor, I am one of the investigating officers in the ongoing investigations that IPO is currently conducting in regards to the brutal murder of Albert Omondi Ojwang. This is pursuant to Section 6, 7, and 25 of the IPO Act. Your Honor, on 8th day of June 2025, IPOA learned the death of Albert Ojwang while in police custody at Central Police Station within Nairobi County. Your Honor, the authority immediately initiated investigations to unravel the circumstances surrounding the gruesome death of the deceased. Your Honor, so far, our preliminary investigations have revealed that the deceased was arrested following a complaint by the Deputy Inspector General of Police.
Your Honor, all that the witness is saying has been said. You can only adopt them from the facts. Because unless there's any other crucial information.
That's another, Your Honor. That's okay.
Yeah, I was of the view, but just give a highlight, not necessarily going paragraph by paragraph, just a highlight, and then we can adopt it. Just a brief highlight.
Okay.
You okay with whatever you've said so far?
Yes.
And whatever you've averred in the affidavit, yeah? So we can proceed with the cross-examination?
Yes.
Is that okay? The other from the state?
That's actually not that.
Okay, okay.
They can proceed to examine on the affidavit.
Thank you. Your Honor, I'll be asking the witness to brief.
So, Mr. Benson, maybe just for housekeeping in good order, how many of you will cross-examine him?
3.
3. You, yourself, and who else?
Me, what? Kangai.
So only 3 of you from
Yes,
this
we'll
battery-
cross-examine him.
The three
The
of
others will submit.
I think that is okay.
Thank you. Mr. Jibril,
Yes, Your Honor.
kindly confirm your position at IPOA over this matter.
You are asking my rank?
Yes. That's a must.
Your Honor, as indicated, I'm a senior assistant director investigations.
And confirm that you are an investigator.
Yes, Your Honor.
Are you an investigator in the purpose and the name or position of the National Police Act?
IPO Act.
Under IPO Act. And under IPO Act, is it true that you have still arrested powers?
Yes.
Under which section?
Your Honor, Section 7 of the IPO Act and Section 7 of the IPO Regulation Act actually gives me the powers, privileges, and immunities of a police officer.
So Section 7. And which section?
Both Section 7 in the IPO Act and Section 7 of the IPO Regulations Act.
Gives you the powers as that of a police officer.
Yes, Your Honor.
And in this matter, you are now actively participating pursuant to those provisions as an investigator.
Yes, Your Honor.
Thank you. Are you well conversant with the law?
Depends on which area you want to ask.
Are you, you know, some of us went to teach, then we became lawyers. Some people are mad about that. Do you have any legal training?
Yes, yes, I do.
Could you refer the court to your legal training?
I'm an advocate of the High Court of Kenya.
Thank you. You are an advocate of the High Court of Kenya. Look at the Criminal Procedure Code, Section 386, as an advocate of the High Court of Kenya. Could you be given it?
Your Honor, we will have an objection.
I've not asked the question.
We can see. Your Honor,
I've not asked a question.
Your Honor, at least should I be allowed to make the objection?
Yes.
Of course.
Let me just object, then you
No,
can.
no. You wait until I ask. I've just told to look at it. It might be just to admire it. Allow me to ask.
Your Honor, we'll be requesting the court.
Mr. Nelson Omar,
Yes.
let's hear his objection.
Okay, all right.
That's right.
Yes, thank
Your
you.
Honor, the witness before the dock
Yes.
has come here on the basis of his affidavit on the factual matter. And that explains why the defense requested that my colleague, my learned senior, does not go into the facts. Section 386 of the Criminal Procedure Code, or whatever provision of the law, is a matter of law. And Your Honor, the objection again goes into the earlier intended preliminary objection, which we have had sight of, where the argument, in a sense, is that this matter, now we have had a copy, although it's not filed, this matter should have been the subject of an inquest and not a miscellaneous application. So that because we are alert, the defense should not try through the window to bring in a preliminary objection which they admitted not to have filed. But more importantly, that this is a witness of facts, not a witness of the law. We can deal with the law between the lawyers. Thank you.
Your Honor,
Is the law a fact? Yes, it is. Is he in a court of law? Yes, he is. Is he an advocate? He knows it. What is it that they are fearing and telling us they are coming through the window? If they come through the window, please respond and throw us out of the house.
There is a submission.
You know,
I've not asked any question. I've only told you to look at that section.
but just for guidance, you know, it's a matter of evidence on the facts. And it's an affidavit, for heaven's sake. So let's leave it to the facts of it.
After I've asked the question,
Yes.
then that is when an inference can be done, whether it's a question of law or a question of fact.
All right.
I've not asked what. I've only told you, look at section 3.
Your
Only
Honor,
that.
just one more thing. The reason we requested the defense at the very onset to inform us of the paragraphs is that the cross-examination is limited to the contents of the affidavit.
True.
There is no reference to section 386 in the affidavit. They cannot go to it because it is not a matter of fact. If you pointed to us the paragraph looking at section 386, which we referred to, there will be no objection from our end. But because affidavits are pleadings of fact, we plead with you to reject the invitation of the witness to look at section 386 or any other provision of the law. Thank you.
I think he was referring to section 386.
Yeah, I just only
So-
told you to.
Let's not convolute it. Let's limit. It's an affidavit.
Purely, I've not asked any question, Your Honor. If we only had what I've asked, and I ask a question of law, then the court can stop.
Okay, then proceed and ask.
Let him have that. Let him look at what
But you know,
I've
once
done.
you point it to the law, then it means
No, no, no.
it's a point of law.
And that exactly is our objection, that we can't refer to the law. That maybe, see, a counsel is not understanding our objection.
Very well.
Maybe
All right.
counsel, maybe rather than asking him to look at the law, why don't you put the questions to him?
Correct.
All right.
Just put the question
All right.
rather than us going
Very
to
well,
the.
very well, very well, very well. From your affidavit, confirm the place of death of the late.
Central Police Station cells, Your Honor.
Central Police Station cells. From the POA Act, provide the mandate for you to investigate somebody dead in a police cell.
Yes, Your Honor.
Read, show the court. Because you have confirmed the scene of death is at the police cell. Which mandate gives you that power?
Still point of
Let him answer.
we are still objecting. Council is still taking the same route.
He came under the act. You know, section in this miscellaneous application, paragraph 3, they must have said under which mandate they are coming before this court. And this is a witness.
This is our witness now.
He's not an advocate. Let him come in front of you. Let him not be given answers.
No, Your Honor. We plead with our colleagues to just remain respectful. We know that they are very good people. Let us maintain the decorum. What we are asking is, as the court has suggested, put the law to the witness. Don't ask the witness to refer to the law.
Very well.
We do not mind if you read the law to him and ask questions.
Read paragraph 3 of your affidavit.
Please read for me so that I can answer.
No, you read it. I didn't write it.
Which one?
Paragraph 3.
That investigations by IPOA are pursuant to section 6A, 7.1, and 25.1 of the IPOA Act.
Is that the law?
Yes.
Is that a fact or that is the law?
That is a fact as per this affidavit.
That's what I'm saying.
Yes.
You have quoted the law. True.
Yes.
Therefore, it is not wrong to ask you a question of law because it is you as in the affidavit talked the law. Give me the law that gives you mandate to investigate a person who dies in a police cell. What is it?
I have indicated the sections 6.1, 7.1,
Tell
and
the court.
25.
Just
Yes.
tell the court.
Your Honor, I have indicated section 6A, 7.1, and 25.1 of the IPOA Act.
Could you kindly read to the court those sections that gives you that mandate? The IPOA, just read to the court. those sections for the benefit of the whole one. We don't work for report.
Your Honor, because we did not anticipate that a witness of fact will be made to read the law, we didn't carry a copy of the IPOA Act. If they insist that they want to read it, let them just read it.
Wait from follow selective amnesia when he is cornered. It is there. On any phone. Just read it. Read the section. 6, you read.
Okay. Section 6, Your Honor talks about functions of the authority. Yes. Here means IPOA. Yes. That the functions of the authority shall be 6A, investigate any complaints related to disciplinary or criminal offenses committed by any member of the service, whether on its own motion or on receipt of a complaint, and make recommendations to the relevant authorities, including recommendations for prosecution, compensation, internal disciplinary action, or any other appropriate relief, and shall make public the response received to these recommendations. Shall I continue?
Yeah, anywhere where the death of a person in police, specific and my question is specific. Can we allow the witness to read?
This is a question. Sorry, Your Honor.
Before you even say that, this is a question that has been put to this witness. It is about what he has said in his affidavit. He is being asked to justify why he is here and what gives him the powers. The state, who has not been asked a question, can now stand and start giving him answers or start supporting him. Let him answer.
Mr. Soruti?
Yes.
You have
Yes, Your Honor, I just wanted to indicate. Section 6 has been referred to in the affidavit. The witness has been asked to read, he has read the affidavit. The witness is being asked about the law supporting an action which is not in the affidavit. That's where the difference is. The witness is saying that Section 6 allows us to do A, B, C. But counsel is asking, does the law allow you to do A, X, which is not in the affidavit? We believe that by him having cited to us the paragraphs he would ask questions on, asking the witness about the law allowing you to investigate deaths in cell, which we have not referred to in the affidavit, is going outside the affidavit. But we would be guided.
So So let him answer. If it falls under the ambit of that section 6, let him just say.
That's right. That's right.
Under that provision in the law, and let's leave it at that.
That's right. That's right.
And the question we are here about is specific to death inside a police cell. And that is all I'm saying. If he says that section, then the court will go and make a ruling out of it. That's all we're asking. In relation to death in a police cell.
In police custody.
It's not you to set my question. I've asked you my question. You can't set a question and answer yourself.
So, Mr. Jibril,
Yes.
If it's not there, it's not there.
the question is, do you have the powers to investigate?
We have powers to investigate death that occurs under police custody.
And that's good enough.
Yes,
That's
and custody includes
The
cells.
court has gotten what we have asked. The question has been answered. We'll do submissions on it. That's all. Let's go to paragraph. Paragraph 7. You have paragraph 7?
Yes.
Read to the court what that paragraph says.
Your Honor, the paragraph says that the respondent was arrested on 13th June 2025 by DCI officers and subsequently handed over to IPOA and was later booked at Langata Police Station via OB 50-13-6 of 2025 at 18:05 hours.
The DCI officers arrested him at what time, according to your there?
He said around 3.
You read exactly what you're saying.
I've not indicated the time.
That's what I'm asking.
Yes.
It is not indicated when the DCI officers arrested.
Yes.
Where did they arrest?
At the DCI headquarters.
And not Eldoret.
No, Your Honor.
confirm that the accused was not arrested at Eldoret. The respondent.
According to the officers who handed over me to Mr. Taalam, the officers informed me that they arrested him at the DCI headquarters.
Thank you. I'm putting to you that IPOA released a false information to the public that he was arrested in Eldoret en route to escape to Uganda.
That is not in my affidavit.
I'm saying what is in social media is that the respondent...
Your Honor, I can only answer what is on this affidavit.
Sorry, Your Honor.
Let's not digress to those issues.
Yes.
Yes.
Let's proceed on the question of arrest. Are you aware the Director of Criminal Investigation, my friend Mr. Mohammed Amin, said the respondent is a person of interest?
That is not in my affidavit.
That's why I said, are you aware? If you're not aware, you're not aware.
Counsel, please ask me what is on this affidavit. I'm not going to, Your Honor, I'm not going to answer anything outside the affidavit.
I put it to you that based on the DCI mentioning the respondent, on that day at 2 p.m., he presented himself to the DCI headquarters in the presence of his advocate, Juan Keton. Were you aware of that?
If you said so.
And the DCI authorized these officers together with the advocate to present the respondent to IPOA headquarters.
Your Honor, we have said time and again.
I'm putting it to you.
Please,
You don't need to answer.
please answer me ask me what is in my affidavit. Let's stop charges, Counsel.
Counsel, I've only put it to you, I've not asked you the question.
Is it in my affidavit?
I'm
The question I'm asking to you is it in my
For
affidavit?
the
The answer is
benefit
no.
of the court, I'm putting to you, then I'll ask you where you are saying you are arrested.
Your Honor, I will decline to answer anything which is not in my
I've not
affidavit.
asked. I've not asked.
Then please ask.
I put it to you that the officers handed over the respondent to IPOA in the presence of Mr. Keto. As I put it to you, for the record purposes.
Samson Taalam was brought to IPOA head office by DCI officers.
And he did record a statement at IPOA in the presence of his advocate, Juan Kiprono. Who is it?
Is that in my affidavit?
I'm putting it to you, counsel. You are a counsel. When it's a question, I'll ask you a question.
Please,
I'm only putting it to you
please
for
ask me
knowledge
questions.
purposes. So now, if those are the facts, look at the paragraph you said he was arrested. Paragraph 7. Now I'll ask you questions from there. Read.
I have read and read. What is the question, please?
It's a long day.
No, it's a long day, yeah? It's okay. It's okay.
The state is rich, it can bring water.
Yes.
For both of us and council. It's a long day. Can you confirm that paragraph 7 is not true, that he was arrested by the DCI officers?
The respondent was arrested by DCI officers after he presented himself and brought to IPOA.
Do you have any evidence material to that effect? I've given you the scenario the way it was.
No. The fact that he was brought under the escort of DCI officers means he was arrested and brought to IPOA
The
office.
court has taken that. Let's go further.
Sorry, Your Honor, I think this may be my last objection. We hope that counsel is not proposing to court that he has an alternative set of facts which the court should take note of, because counsel is not a witness. If he wants to give us his alternative facts, we would expect an affidavit so that we also put him on a dock and cross-examine him. Until then, the only factual matrix we have is the one given by the witness before court.
The only way to prove falsehoods is by bringing facts that are truthful. The affidavit is full of falsehoods. We are putting exactly the scenario, and your witness has not recounted any.
So, sorry. Your Honor, I am a believer on the law and procedure. What I understand by the law of affidavits is that a person cannot give us factual matters, especially a lawyer or an advocate, from the bar. Right now, we have affidavit evidence given by this officer. We are having an alternative set of facts, which may be true. We have no reason to doubt it. But until we have an affidavit, all that is telling us is, I put it to you. And we hope it does not go to evidence.
Just to allay you here.
Yes.
The evidence that I'm documenting is from you.
That's right. Thank you very much.
Not from Mr. Johnson.
Thank you.
Because as we put it rightly, he's not giving evidence.
Correct.
He knows the procedure.
That's why
He's a teacher of the law.
Yes, thank you. And that's why I told you, Witty now is mature to be a judge of the high court. Thank you very much. Let's proceed, Your Honor. Paragraph 9.
Yes, Your Honor.
Paragraph 9.
Yes.
You have said what? About the position of the OCS?
That the respondent at the material time of the incident, he was officer commanding Central Police Station, exercising command of the Central Police Station, hence persons of influence, and has capacity to interfere with the ongoing investigations and likely witness.
Do you have any evidence to show that he was in full command of the police station?
As an OCS, that is.
I've asked a simple question. It is either you have it or you don't have it. Do you have anything, either duty roster or something showing he was on duty or in command?
Your Honor, what the advocate is asking is that you are the presiding magistrate here. Do you have the power over this court? I mean, once you are an OCS, you have got a power over that station. Come on, counsel.
We have agreed that you don't have it. You are looking for it. Let me put it and let me put it to you.
And Your Honor, just to answer also, whatever evidence that I had, I have put as an extra. Anything else which is not here is purposely done to safeguard, first of all, the integrity of the investigations. And they will be provided at the most relevant time. I'm well aware that this will not be the forum where those charges will be preferred. Yes.
So I've asked a simple question.
Yes.
Among the annexures,
there are none.
You produced an annexure showing he was in command of the police station at the time the offense was committed?
I recorded his statement and he confirmed that at the time of the incident he was the officer commanding station at Central Police Station in the presence of his lawyer. I have not attached in this affidavit.
Simple. The answer is clear. You have
Yes.
not attached. All that's what you are looking
Yes.
for. It's not attached there.
And maybe to answer your question, any other attachment that you might ask is not there, save for the OB extracts.
Just don't move. And you are a lawyer. When I say I put it to you, don't respond. I've not asked any question.
Then why are you putting in the first place? Why in the first place?
You can put it there. You can put it all over.
Really went to law school.
So that's if you don't want answers to those questions that you're putting,
I
you're
know.
putting a lot of putting in.
Yes.
See, we have our own legal here. Allow us to proceed. What is relevant, record. What is not relevant, leave it. I put it to you that the police station and the deputy was in command as an OCS.
That is not in my affidavit.
And I put it to you that the OCS was never near Central Police Station.
That is not in my affidavit.
Thank you. The world has had something. Let's go, paragraph 15. On the question of him likely to plan. You there?
Yes.
We have agreed there is no any material.
Yes, nothing
Thank you.
attached to
Let's
this.
proceed.
Okay.
Paragraph 10.
We go back.
Oh, I asked you paragraph
15.
15.
Yes.
I'm going to paragraph 16, sorry.
Okay.
till no material attacked. It is either very serious material you have kept, no material attacked.
Yes, Your Honor.
Thank you. Paragraph 17 about the CCTV.
No material attached, Your Honor.
Thank you very much. Paragraph 18.
No material attached.
No material attached. Paragraph 17.
Come on.
I've gone back because there's a question I want to ask.
Yeah, please ask.
You have said about the CCTV cameras. Do you have possession of the scene of crime as of now?
No.
Who is in possession of the scene of crime?
The scene of crime was processed and released. Remember, that's a police station. You cannot hold a station as a crime scene for a very long time. So we have released to the relevant authorities.
Is that on off? Because I was there yesterday. It's not true that the scene of crime has been released to the police.
Then
Is it still a scene of crime, or it is non-operational police station?
that question is not. It's not in the affidavit.
You've run very fast. You cannot lie that is. So you cannot. There's no material to show that.
Nothing attached, Your Honor.
Paragraph 19. You've read it?
Yes, Your Honor.
And 21, they are the same.
What's the question? No material attached.
There is no material attached.
Yes.
That is very, very critical to us. Paragraph 22. I still ask you this question about the blue code of silence.
I will refer you to the High Court decision.
Tell the court. This is a lawyer. He knows the court decision.
Court of Appeal decision.
Give the court that decision.
In the Titus Ngamau case, 2020. It was a phrase coined by the judge who was dealing with that matter.
And I remind you, Cliff is the one who argued that matter.
Yes.
He'll face you over that matter.
It's okay.
He's the one who argued that matter. Cliff will deal with the blue code. Paragraph 23. You are now providing reasons as to why you want him to be detained for 21 days. True? From paragraph 23.
Yes, Your Honor.
What is the reason you want to detain him? In paragraph 23.
That we are yet to record critical witness statements.
Very well. Is his presence required physically when you are recording statements from other people?
His detention is required so he doesn't interfere with the witnesses.
Avoid recording statement and interference are two things. Wakili,
I have responded to your question. The reason as to why I'm seeking that prayer is to have him detained so that he doesn't interfere with the witnesses.
Very well. Does he know the witnesses?
Them being police officers? The answer is yes.
Is there anything you have shown of any attempt to interfere with witnesses? Because, Counsel, you know very well the authorities, the Sagari, Duat Sagari, Cliff will ask you. The questions I'm asking is to prove, have you demonstrated by material your varmint?
Nothing attached.
Thank you. The court has said. Paragraph 24. What are you addressing?
That we are saying if released, his security is not guaranteed due to the public anger demonstrated by the case. I've just read what is in the affidavit.
Yes.
I'm saying that the crucial murder of the deceased has elicited widespread public anger, and therefore, if released at this point, the respondent's security cannot be guaranteed.
Mr. Witty took us a lot about the case of Oscar Sudi. Heavily. Have you ever had a chance to read paragraph 32 of that decision of Professor Justice Joel Ngugi?
Not in my affidavit.
It's not in your affidavit.
Yes.
For the benefit of doubt, you are saying you want to detain him on two limbs. One, for the safety of his life. True?
Yes.
Do you have anything to show that his life is in danger?
Nothing attached.
Do you have anything to show that he is a danger to anybody of the public?
Nothing attached.
So it is an apprehension.
Yes, Your Honor.
Thank you. It is an apprehension. Lawyers swear to be court officers. It is an apprehension. And you are very aware that the National Police Service is the one mandated to provide security for everybody in this country, including the already convicted murderers. You are aware of that?
It's not in my affidavit.
No. You will fail to be not understanding what I'm asking. I'm asking you this question. The duty to protect life and property falls under the police.
If you say so.
And this country is not a banana country where the rule of law has broken. So it is not right to say you are preserving his life in cell. And he pays taxes. Everybody pays taxes to be protected. And that it will be dealt with in the cases that I've talked about. Now, what other reason do you need him in cell to detain him for 21 days?
All I stated
what
in my
do you specifically want him to do?
All I have stated in my affidavit.
Is there any other reason we have not dealt with?
Everything I require, I have indicated in my affidavit.
Confirm you have his phones.
His phone.
His phone, you have it.
Yes.
And you are seeking this court. Did you have the court order to possess that phone?
I don't need a court order to possess a phone.
Do you need a court order to get access to the phone?
Yes, I do.
Where is the provision that does not allow you to have authority to possess?
It's a seizure.
Oh, wait, allow me.
Yona, where is the provision that does not allow you? Surely.
Where is
You
the
are asking
provision?
for a provision which does not allow you. This is a negative provision, does not exist in our law. He should tell us the positive provision, and counsel can put it. He can continue putting him to him that this provision does not allow you, not the negative provision.
Maybe rephrase your question.
I'm rephrasing. You know, which has a problem is preparing for the judge. It's not akin to this matter. You need him 21 days for the sole purpose of granting access. Is it him who grants access or the court?
No, Your Honor.
Who grants?
I need the 21 days to complete my investigations.
I've asked a question specific. Do you need my client in cells for the purpose of analyzing the phone?
I need your client in custody for 21 days to complete my investigations.
I've asked a simple question. Is there any role he's required to do in forensic analysis of our phone?
I'm not an expert in forensic analysis, so I cannot say.
So, your arguments are not based on any scientific, because you never consulted a forensic expert? It is you swearing 21 days.
Yes.
And I've asked you, should the court why 21 days? Why do you need him specifically?
Your Honor, the issue is not about only phone extraction. It's not only about phone analysis.
What else?
I have said to complete my entire investigations that entail so many things. Among them, what you have stated.
And lastly, you have already attached the order in your application. Look at it. We have an order. True. Makori, this is a competent advocate and witness. Let him answer.
No,
I have seen an annexure here.
Can I check, yes?
I've seen an annexure there. We were given an annexure that has. Is it yours?
Yes.
Or it is on it?
No, it's ours.
Very well. Let me ask you the question. You are certain you are getting
It's a draft.
these orders?
Counsel, this
No.
is a draft.
No.
It's a draft.
Which is saying, is the office of the DPP or a POA that gives the orders, or is the landed court? What is the import of you drafting an order? Is it a formality that in this court already you have decided, not the court itself? Who decides? I hope it ceases from being.
I hope we can save time by admitting that the application was drawn by the office of the DPP. What we have annexed as an order is a draft order. It is not the first time today. Is it 18? It has been done since I was a law student at the University of Nairobi, where we do draft orders. The court can reject it. It's not binding on the court. So that we save time for counsel and his client. We
Which have only for good practice.
We admit.
Avoid doing the judicial work. Leave the courts to do their works.
So maybe Mr. Whitty, let's not delve so much on that here.
Yes.
I think what Mr. Whitty is saying is just practice that they have adopted from the DPP's end, which is not a good practice.
It is not good practice.
So let's leave it at that.
If I sat in that office, I wouldn't allow that. But I was chased. Thank you very much. Let me allow Mr. Kongai to proceed. Oh, sorry. You already said if an advocate is not allowed to talk, I will be stoned out. Put Mr. Shadrach on board. He has just left class to come out. He was teaching till he's late on the forum.
So, Mr. Katai, Mr. Shadrach.
They will release Shadrach, then
We're just trying to put in order. It should be a difficult one. After Mr. Shadrach, Mr. Keto will play his legal basis. Then I'll figure out the application. I think Mr. Umbeta and Mr. Njui will be making a submission on that one.
Your Honor, with your permission, I will ask very few questions to my colleague, Mr. Jibril. Unlike my seniors, I am the soft one.
And I hope you are around so that you don't ask again the same questions which I have already answered.
Yes, I teach law. Just relax.
Mr. Jibrin's sentiment is valid.
Yes.
I was about to make the same commentary.
The problem is his body. Cliff, make sure he eats well.
So that we can avoid repetition.
Thank you. Mr. Jibril, I want you to confirm to the Honorable Court that indeed one person of interest in the matter surrounding the death of the late Albert Ojwang is the Deputy DIG Edward Lagat.
Please repeat the question.
I want you to confirm to the Honorable Court that the late Albert Ojwang was arrested pursuant to a complaint made by the DIG, Mr. Eliud Lagat?
Yes, Your Honor.
Thank you. You also want to confirm to the court that from your preliminary investigations, the late Albert Ojwang was arrested and put in police cell, largely due to the complaint that was made by Mr. Eliud Lagat. Is that correct?
Yes, Your Honor.
Thank you. You confirm to the court that the investigations you seek time to continue with are investigations meant to assist you to unravel the persons who should be held culpable for the death of Albert Ojwang. Is that correct?
Yes, Your Honor.
Thank you. Please inform Your Honor the name of the chairperson of the body where you are coming from.
Your Honor, I think we have agreed that what I'm going to answer is what is in my avowment.
Please just listen.
No.
This is cross-examination.
I decline to answer that question, Your Honor. It is in public domain who is the head of IPOA.
Just respond. That is your work here.
I'm responding.
Please respond. Who is the chairperson of IPOA? That is your work.
My response is it is not in my affidavit.
Yes, yes. JV just inform me.
No.
I mean,
Your Honor, we have agreed that I will be cross-examined on what is in this avowment. The chairman of Independent Police Oversight Authority's name or his position is not in my affidavit.
But you know you come from that
Yes. Yes. And the council knows who is the chair of the IPOA.
Please answer the question. Who is the head of the body where you hail from?
We don't have a head. IPOA does not have a head.
So who is the chair of the IPOA?
Yes, that should be a right question. The chair of IPOA
Answer, yes.
is one Ahmed Hassan Isaac.
Thank you. Thank you. Now, you confirm to Your Honor that there was a joint press conference on the 9th day of June 2025. Is that correct?
Your Honor,
No,
I'm not going to answer anything outside my affidavit.
Your Honor, if you permit me, just to also give context why I am asking this question. Your Honor, my learned senior and friend, Mr. J.V. Owiti, went to a very large extent in explaining the authority that was made by my Lord Professor Joel Ngugi in the Oscar Sudi case. Some of the parameters that were set by the Honorable Court were two. I think that is paragraph 24 of that authority. On the question about bad faith, the question about exceptional circumstances, and lastly, the balance of the quadruple rights that the court should look at. One of the items that we have a duty and responsibility to prove to you is to demonstrate to you that indeed there is an element of bad faith in the application that has been made before you. And that is why my questions are aimed at eliciting some of these facts based on the evidence that is going to present before you. So, Your Honor, I plead with humility that counsel, my colleague, I even suppose is my senior. My senior should just
No, I'm not your senior.
kind enough to
I'm not your senior.
Yes, it looks are deceitful, but
Your Honor. Yes. Yes. Your Honor. No. Order. Chair. Let me say this. Let me say this for the record. No, let me say for the record. And Your Honor, protect me. The counsel who is on the floor asking questions should only answer. Learned senior should stop pointing at me. You will have your time to ask me questions if you require. The second, Your Honor, the second point I'm making here is that anything outside this affidavit, whether our chair is not within my knowledge, and please stop asking me. Anything outside this, I'm not ready to answer. It's not within my knowledge, and believe. And after all, Your Honor, the application we are making is about an extension of continued detention of the suspect. It's not about what happened on the backyard. What you are pointing is bad faith.
That's why it was trying to clear basics.
You just give us a minute. No, we don't need a break. I think just
No, we don't need a break. We don't need a break.
just 1 minute.
That is what they are doing.
It's our intention of making a pass. If they ask for the chairperson, please just answer. If they see them crossing the line, and the first so don't let us see this that we fair. Okay. Yes, that's what they're doing.
We are not like this. Calm down.
So calm down. Just answer what it is. Yona, thank you. Thank you. I know.
Let's just have civility and decorum.
Yes.
They don't fight you.
Yes.
Thank you. Thank you. Mr. Jibril.
Yes.
Counsel, please confirm to Your Honor that there was a joint press conference on the 9th day of June 2025 where the chairperson of IPOA was in the company of Mr. DIG Eliud Lagat and the Inspector General of Police and others.
I'm not aware.
You are not aware. Thank you. So you have not, Your Honor, you have no information that indeed your chairperson held a joint press conference with one of the persons who's been constantly mentioned in the death of the late Albert Ojwang. You have no information, isn't it?
Your Honor, the chair attends several press conferences.
Leave those several.
So I don't follow the chair.
Thank you.
I don't follow the chair for his press conferences.
Thank you. Now, Your Honor, that is very important. You have been very honest with the court. Now, I want to return to paragraph 27 of your affidavit. Yes, paragraph 27. You have made mention that the reason why you are inviting the court to order the pre-charge detention of the suspect before court is because you have fear that he might run away from the jurisdiction of this court, isn't it?
Yes.
Have you, in your well-elaborate affidavit, demonstrated an instance where probably he was invited, he never turned up, or you have proof that he has already booked a ticket to a certain foreign land that you have presented before court?
That is not in my affidavit.
No, you have in your affidavit.
No, I'm saying
yes.
the answers that you are looking for is not in my affidavit.
No, I am asking a very straightforward question, likely to attract a yes or no.
Yes.
I am asking you again. In lieu of your paragraph 27, on the question about the temptation by the suspect to run away from the jurisdiction of this court, if allowed his liberty, have you provided before this court
No.
any material?
No.
You don't have any material?
No.
Thank you. Your Honor, that should be all for me. Thank you.
The two I'm actually going to take very limited time in the form of 2 minutes. Stop it.
Then I can do 125 minutes, depending on how it's going to answer. Now, Mr. Jibril, I want you to remember the testimony that you've given us just a few minutes ago, where you told us that the scene of crime was processed and released to the relevant authorities. Is that still your stand?
No, it's not in my affidavit. That's my answer.
You,
yes.
You made a representation to this court
and told us that the scene of crime was processed and released to the relevant authorities. Is that correct or not correct?
Now, Your Honor, the scene of crime here I'm talking
Is it
about.
correct or not correct?
The cells where the deceased died has been processed and released to the relevant authorities.
Thank you. Now, can you tell us the investigative steps that you have used to preserve the CCTV and the occurrence book?
The occurrence book is a digital. It's not.
It's a digital
It's a
one.
digital. Yes, yeah.
Is it with your possession right now?
No, it cannot be.
It cannot be.
It cannot be in my possession.
Have you
Yes.
extracted the relevant entries on that particular day?
Yes, and attached to the affidavit.
Thank you. Now, number two, about the CCTV, can you tell us the preservation measures that you've taken to preserve the sanctity of that CCTV footage?
Your Honor, we are a team of investigators. That aspect is being done by the forensic team.
So you can also confirm that the CCTV itself is not with the police station. It is with the forensic team.
And what was extracted is the only the DVR. But the entire, you can't carry a
It's
whole
okay,
screen.
it's
and
okay. That's what I want you to tell me.
Yes. What was extracted is only the DVR.
Yes.
Yes.
So the DVR that records the events of that fateful day is the forensics team.
Yes.
Thank you. That's all.
Good afternoon.
I kindly allow me to ask you just two questions. I want to take you to paragraph 6A of your affidavit, where you have said the DPO received a complaint from the Deputy Inspector General of Police. Confirmed?
Yes, Your Honor.
Was it an oral complaint or a written complaint?
It was a letter, a formal,
It's a letter.
yes, a letter to the
Have you
DC.
provided that letter this court?
No, it's not attached here.
It's not attached here.
Yes.
Thank you. Kindly go back again to paragraph 7, where you say the respondent was arrested and under the Langata police station, OB number 50.
Yes, yes, Your Honor.
Who booked the respondent at Langata police station?
The booking was done by myself.
It was done by yourself?
Yes.
Thank you. Are you aware of the law governing the booking of a person at the police station?
As per the IPO Act, yes.
As per the above Act?
Yes. And the regulations.
For instance, are you a police officer or a former police officer?
I'm not a police officer. I'm an
Have
IPO
you not been a
employee.
police officer?
Yes, I've been a police officer.
You have been a police officer?
Yes, Your Honor.
Thank you so much. Paragraph 21. Now, paragraph 21, you are saying there are co-conspirators. Confirm?
21, yes.
Do you know the co-conspirators by name?
That is part of investigations. I cannot reveal here.
No, I'm just saying, do you know by name, not their names? Do you know them by name? Because you have said there are co-conspirators. Do you know them? Not by name.
Okay, Chief, you need to name
Counsel, this is what I've been saying. Let me answer. The thing is,
Let me help you with it.
yes.
Just say yes or no. Do you know the co-conspirators?
The matter is under investigations.
Yes or no?
As of now, no.
You don't know them. Thank you so much. Number 25. You have said that there was the murder of the deceased was planned, executed, and their attempts to cover up. Do you know the people who are trying to cover up the death of the deceased?
One of them is your client.
Do you know that with certainty?
Yes.
Have you provided evidence to that effect? Of
No.
the attempt to cover up?
It's under investigation, but not attached to this affidavit.
You have said that, yes, you know the client is one of the people trying to cover up. My question is, have you provided evidence that he is one of the people who is trying to cover
As of
up?
now, no.
No.
Yes.
Thank you so much. Thank you, Honor. That is the
I think, Your Honor, that will be the end of the examination of the witness. We will lay now, once he is discharged, Mr. Keaton will lay the basis for our next line of approach.
Even we would like a few minutes of re-exam because that follows cross-examination. Mr. Jibril,
Yes, Your Honor.
my work is to calm you down completely.
No, actually, I'm calm and composed.
Thank you. Now, I will limit my questions back to the contents of your affidavit, many times by paraphrasing.
Okay.
What is the basis of your request for detention continuing today in one line?
To complete my investigations.
On a scale of 0 to 100%, how much could you, by approximation, attach to your investigations up to now on a scale of 0 to 100%? It doesn't have to be accurate, approximation.
49%.
49%. So I can mathematically say this as direct evidence that you're saying there is 51% of investigations to be done.
Yes, Your Honor.
So that there are questions about who is in charge of the cells, who is in command of the station. Do those questions relate to the remainder of your investigations?
Yes, they do.
Now, to ask another direct question, are the questions from the defense some of the things you need to investigate to complete your investigations?
Yes, Your Honor.
Thank you very much, Your Honor. I'll hand over to Mr. Johnson.
It's just one question in the examination. You have been asked whether you have attached any document relating to, I think it was paragraph 6A, some paragraphs in your affidavit, whether you have attached anything to show that even the respondent is a flight risk. Why do you need the respondent in custody? Is there any reason why you have not attached?
Yes, Your Honor. The reason I have not attached what I've collected so far, the 49% I'm talking about, is that it will jeopardize the investigations. And this is actually to protect the integrity of the investigations. That's why we cannot divulge much.
Thank you very much. I believe that is all from my end.
Thank you, Your Honor.
I'm glad that you confirmed that you were calm.
Yes.
Thank you. And allow the next phase of our team, led by Peter. Now we consider take out as we are only asking for the benefit of
How many will be submitted?
4. There's Kiton, there's Langat, there's Tutsi.
We are fine. The only thing that we'll be asking is there something that has been filed so that you can be served? Or it's an oral? Yes, very well.
We'll serve you with authorities, simply. Our team serve the state with the other.
So just like brevity, because this issue is involved in itself. So just brevity, just direct to the point here. Submissions.
Your Honor, for the record, I remain Felix Keaton. And also, there's also another additional attorney at law, Vincent Yegon, also is part of the defense team.
Present, Your Honor.
Your Honor, we reiterate that we vehemently oppose the motion application dated the 16th of June 2025. And from this motion, Your Honor, there is only one salient issue for determination. That is whether there are compelling reasons for pre-plea, pre-trial, or pre-charge detention has been settled in law, is well settled in law. And as such, Your Honor, Article 49(1)H and 49(1)G of the Constitution is very clear that an arrested person has a right to be released on bond or bail unless there are compelling reasons. Your Honor, in order to conceptualize and also problematize the issue, Your Honor, permit me to refer you to the statute, which is Section 36A of the CPC, of the Criminal Procedure Code. And in order also to contextualize the issue, Your Honor, is that this Section 36A was an amendment following the locus classicus in Michael Rotich, that is in Michael Rotich versus the Republic, the 2016 decision, whereby, Your Honor, in this section, it lays the two-tier threshold for such an application to succeed. The first burden, Your Honor, is on the investigation, that is the IPOA. And the other also burden also, Your Honor, rests with the Honorable Court. And as such, Your Honor, under Section 36A, it is very clear that pursuant to Article 49(1)F and G of the Constitution, a police officer shall present a person who has been arrested in court within 24 hours after being arrested. And now it lays now what the investigation officer must do. First, he must make an application in writing. First, he must produce the suspect in court, which they have done, which we admit that. Then the second thing, Your Honor, is that they must apply in writing. And they have done that through this motion application. But now, Your Honor, the greatest issue that they must also do, Your Honor, is that under Section 36A, clause 3D, it states that the investigation must also adduce the reasons necessitating the continued holding of the suspect in custody. So the question that